have you. Okay, thank you for coming out tonight. This is a topic that I'd love to say is near and dear to my heart. It once was near and dear to my heart, and I researched it and I got angry. And I researched it more and I got angrier, and that was okay. And then I decided I didn't want to be angry all the time, and I stopped researching it. But it's still worth talking about because a lot of people say a lot of things about voting rights and the ongoing debate over voter fraud versus voter suppression. And I think it's worth understanding not just really how that debate ought to be addressed, but why it is addressed. The origin, not just of the debate itself, but the way the Supreme Court had one job to do in 2008 to address the problem, and took a big swing and whiffed on it. And we are struggling with the fallout from that decision, and we've been struggling with the fallout from that decision for a couple of decades now. As many of you know, the Supreme Court just issued a couple of important decisions on voting rights. Most recently, a case coming out of Arizona, in which a ban on out-of-precinct voters, even if it was very clear what the mistake was upheld. Poll workers cannot handle mail or absentee ballots, or only poll workers, I'm sorry, can handle mail or absentee ballots. The discrimination, the impact as far as discrimination under the Voting Rights Act was reinterpreted by the court, so it's terribly difficult to prove the type of bias that is inherent in some of these laws. And that decision came down just this year. A new Texas law was just passed a week and a half, almost 2 weeks ago, that addresses voter integrity, restricts early voting, restricts registering voters, and restricts voting by mail. Voting is the heart of our political system in a lot of ways. Voting has been treated as a fundamental right, but also mistreated and confused over our history, partly because of the legacy of slavery and the legacy of limited access to voting early in our history. And ultimately, it looked like we had turned a corner a few decades ago. And that's when, again, the Supreme Court had this case, Crawford versus Marion County. The whole thing was teed up for the court to not overturn beliefs and not overturn the myths and the misunderstandings, but certainly to state what the law had to say about those myths and about those misunderstandings. And so anyway, let's take an in-depth look at some of this. And again, I have to play a little bit fast and loose with how much detail I go into. So here's my first example of streamlining. There is a long and rich history of voter suppression in this country. There's a whole bunch of detail, but we're not going to talk about it. Sorry. If I were to talk about it, I would talk about slavery, and I would talk about the gradual relaxation of the franchise and letting former slaves vote and letting women vote and letting removing some of the barriers like poll taxes and allowing younger people to vote. And we've moved in that direction, but we also saw a series of laws passed up through Jim Crow and then up through the 1960s. And then we saw a series of laws to try to combat that. And again, it looked like in the 1960s and into the 1990s that we had turned some kind of a corner. The truth is, if you look at the language that the Supreme Court has put forth in the last, over our history, it's a mixed bag. I'm not going to stand up here and say the Supreme Court said voting is a fundamental right, and it always has, and because it hasn't. But this is what we saw in some of the key decisions in the later part of the 20th century, latter part of the 20th century. Our Constitution leaves no room for classification of people in a way that unnecessarily abridges this right. This had to do with treating minority groups differently for purposes of determining the vote. This case had to do with redistricting, but that's the language. It's the language of fundamental rights. That's one example. More recent example. Voting is one of the most fundamental significance under our constitutional structure. A state may not burden the right to vote merely by invoking abstract interests, even if they're compelling, but must make a particular factual showing that the threats to its interests outweigh the particular impediments it has imposed. That's the language of strict scrutiny, which is the standard that the Supreme Court uses for fundamental rights. So this is something that has gradually been, again, fairly well established in the latter part of the 20th century. Simultaneous with that, we saw, again, a series of laws. The Voting Rights Act passed in the 1960s, the Motor Voter Law, the Help America Vote Act. We had a series of these laws, and the Supreme Court appeared poised to at least hold voting to a higher standard than the lowest one out there. Okay, without going into a detailed analysis of the way the Supreme Court treats fundamental or important or less important rights, compelling state interest under fundamental rights is the first standard. The state, in order to restrict fundamental rights, must show a compelling state interest and must show that the restriction that it is using restricts that right the least amount possible, least restrictive alternative. If it doesn't choose the strict scrutiny standard, if the court says, well, it's a lesser standard, it's intermediate scrutiny. Intermediate scrutiny says there must be an important state interest, and the restriction on voting must be no greater than necessary to achieve that interest. That's still a fairly high standard. The rational basis standard, however, basically says, does the government have the power to regulate in this area? And is the policy arbitrary, capricious, or deliberately discriminatory? It is a very easy standard for the state to meet, which means it's easy to restrict voting if that's the standard they use. So while voting is a fundamental right, at least the way the courts seem to be presenting it, it is also clearly, and has been for a long time, a partisan issue. We can't avoid the fact that it is a partisan issue, and it has been for some time. So now you're juggling multiple considerations. Now, what do we mean by that? What are the implications of voting being a partisan issue? We saw a resurgence of voter suppression beginning in the early 21st century. Number of factors for this, and this is another place where I'm going to streamline a little bit. The political parties, platforms, and coalitions have created a divide. We have one party that it is in their interest, because of their base, because of the structure of who their voters are, that it is in their interest to reduce turnout. The Republican Party has a smaller base, they're more loyal, they're more reliable voters. The Democratic Party has a larger base and a larger share of likely non-voters. So it is in the interest, in terms of the partisanship and the struggle between the parties, for the Democrats to want more voters and the Republicans to want less voters. Okay, well, that's nice. That's a good understanding of partisanship. Here's the problem. It has coalesced into a debate over voter fraud versus voter suppression. There is a myth out there about voter fraud, and this myth has become the central part of this debate. The reason that this is the case is because nobody can say with a straight face politically, certainly not publicly, broad scale, well, the goal is to make sure that these people don't vote. You don't say that, right? You say, we have to restrict voting because there's a problem with fraud. Or there's a problem with how the system is working. You don't say the strategy is to just make it harder for some people to vote because that's going to hurt our electoral chances. Sorry, breathing here a little bit. So, little bit of illustration of this. I think this will help to try to clarify it. We like to talk sometimes in terms of this voter fraud issue about everybody has an ID, or everybody should have an ID, or it's very easy to have an ID. Well, some citizens have a standard photo ID, which is a driver's license, but some don't, and there are patterns. Minorities, certainly Latinos and African Americans, a lot more of them don't have the classic ID that is pretty much the standard. Annual income, right? There are issues with income in terms of voter access and what some of the laws and policies are. You see the difference here. Who don't have the ID. If you're poor, you're much less likely to have the ID. And if you're younger, you're much less likely to have the ID. No big deal. Aha. Who do they vote for? There's the incentive for the partisanship. Now, again, you can make the argument that that's all it is a partisan debate. The problem is that, as I said, you can't really say we don't want them to vote, or at least you can't say that out loud. So what you do is you talk about the voter fraud myth that plays to the Republican base. For a long time, this was not a Republican-Democrat issue. If you go back into the 1960s and before, in fact, it was the Democratic Party years and years ago that was the one driving, trying to restrict the votes of African Americans. But that has changed, and we have today a very clear delineation between the two parties over this issue. The Democrats, by the same token, cannot say there isn't any voter fraud, because there is. A little bit. Enough to make a difference? No. Enough to be coordinated? No. But it is not true to say there's no voter fraud. It happens less often than getting struck by lightning, but it happens. People show up pretending to be somebody else. Maybe once out of every 3 million voters, something like that happens. And so again, if you can't be absolute, you're vulnerable in the debate. And to be honest, the Republicans are far better at messaging, and they're a lot more ruthless on these types of issues. But this is a partisan fight. And there are implications to this being a partisan fight. And we can see this when we look at the motor voter law, which was the one that said you can register at the DMVs, landmark piece of legislation. Look at the way the voting aligned between the two parties. This is commonplace. This has only gotten more intense in terms of the division between parties. And there are a whole series of efforts that were attempted to build this myth and to act on this myth, that there is voter fraud and it is a problem that needs to be addressed. The Bush administration ordered attorneys general around the country to investigate voter fraud specifically by the other party. And when they did not find anything, some of them were told to resign. Some quit in protest. It became a major media story. There were state investigations. There were some federal investigations, all designed to find the voter fraud. Even if it wasn't found, and it wasn't, it's been repeated and repeated and repeated to the point where over 70% of Americans believe there should be a photo ID requirement to stop voter fraud, even though we know there is no voter fraud. Okay, with that as the background, there are a couple of problems, and I've hinted at these problems, but let me stress this so there's no mistake as far as where I come down on that issue, because I'm pretty good at being oblique, a little bit oblique, but let's just, first of all, 3 major problems with voting as a partisan issue. First and foremost, voting is or ought to be a fundamental right. In a democratic society, a representative democracy, voting needs to be protected. It needs to be treated as, if not a fundamental right, very close to it, protected by the judicial system, the legal system, because we obviously, at least as we've seen, can't trust the legislatures to protect those rights. So that's the first point. The second point is that the voter fraud myth is false. No two ways about it, the myth is false. Quick illustration. Frequency of possible voting fraud, voter fraud, fraudulent voting in federal elections. There have been a lot of studies done. I researched all of them when I was involved in this project for years. And Justin Levitt's is the best and most thorough research out there. This is how much voter fraud he found. Again, this is not clear voter fraud. This is plausible voter fraud. It is quite possible that many of these cases actually weren't voter fraud. They were honest mistakes. They were mistakes made by the people registering or checking. But in any event, it's still very little with mail-in and a tiny bit with in-person voting. If that's the case, then we have to ask the third question. And the third question, or the third point, government restricting voting is simply wrong. It's morally wrong, if you want to use that terminology. It is politically wrong. It undermines our democracy. And it doesn't matter if the public believes that voter fraud is a problem. It's not a problem. If the people believe it's a problem, the people need to be told it's not a problem. You don't base laws on misconceptions and misbeliefs, and you don't base policies on restricting fundamental rights that have consequences in our elections. Voters are supposed to choose their representatives, not the other way around. Or to, I guess, I don't know who I'm quoting here. It's probably some weird form of Bernie Sanders' statement. If you can't win over voters or message better or change your policies, then find another career. If you cannot persuade people to vote for you, you need to persuade them to vote for you. You need to get out of the business, right? You shouldn't get to say, well, they won't vote for me, so I'll just not let them vote. And the courts have to enforce our constitutional amendments, and the courts have to enforce the concept of the fundamental right, or else this isn't going to work. It's going to get worse. We're going to have more restrictions on voting. Okay, so all of that comes to a head in 2008 with the Crawford case. And the Crawford case was teed up almost perfectly because the facts were not very good for the government. Little bit of background on this case. In 2003, Indiana and Georgia, among other states, but these are the first two who raised the very specific question of a photo ID requirement. They passed photo ID requirements, and they were challenged in Indiana by the Indiana Democratic Party, some minority voters, and some elderly voters. The state conceded at trial that one of the major purposes of the law was to make it easier for the Republican Party majority who passed the law to win the elections. That was in the record. That's part of why we passed the law, because it's going to help us win. There were no documented cases of in-person voter fraud in the state's history. It could happen someday, maybe, but it's never happened. And that if it did happen, that particular ID law wouldn't stop people from showing up to vote pretending to be somebody else. It would not work. With the facts that way, it was teed up to ask tough questions and to hopefully address the problems with that law. The Supreme Court had its chance to do a few things in this law. First, to confirm that voting is a fundamental right, to at least partially, in the legal system in a case, puncture the voter fraud myth, put some teeth in the anti-discrimination provisions under the 15th Amendment, under the 24th Amendment, under the Voting Rights Act, and to stop some of the partisan games with voting rights. And most of all, maybe, to halt the momentum of voter suppression laws that appeared to be on the verge of getting worse and worse. Apply the constitutional standards, if not intermediate scrutiny, if not strict scrutiny, at least intermediate scrutiny. It was all set up for the court to once and for all say, enough is enough, this cannot stand. And as I said, the court punted on every issue. Here's what we saw for the decision. They upheld the photo ID requirement by a 6-3 vote. The Republicans voted to uphold it. The Democrats voted to strike it down. One quick note, though. At the time, widely known as the most liberal judge on the court was Justice Stevens. And he wrote the majority decision, or the majority opinion. Okay, plurality. He did not get 5 votes for his opinion, but he did get enough he got 3, and then there were another 2 that supported the way the court decided the case. Okay, so what did Stevens say? He said, first of all, here's the standard we're going to use. We're not going to use strict scrutiny. We're not going to use intermediate scrutiny. We're going to use a balancing test, and the language we're going to use is arbitrary and disparate. This is something that the court has occasionally used in voting rights cases, but it is incredibly lenient. Arbitrary and disparate sounds an awful lot like, and has been applied almost identical to, arbitrary and capricious, which is the lowest level standard, which is the test that is used for any law that's out there that doesn't deserve any, doesn't deserve any additional scrutiny, any heightened scrutiny. So that's the first problem. Second, partisan motivation is not a problem. Stevens' quote from the case: the law should not be disregarded simply because partisan interests may have provided one motivation for the votes of individual legislators. It was more than that. The record was pretty clear that the motivation of drafting the law was in part, we can gain an advantage here. There are people who are less likely to vote, and we know who they are, and if we impose this requirement, they're going to be less likely to vote. One of the tricky things about voter suppression laws is they don't ban anybody from voting. They take people that are vulnerable, least likely to vote, and just make it a little bit harder. If you make it a little bit harder, you reduce turnout amongst those people. And again, that's the strategy. What else was in this decision? Maybe the worst part. Public confidence in the integrity of the electoral process is enough to uphold the law. What does that mean? That means that we know that there's not a problem with voter fraud. We know it doesn't happen. We know that there's a partisan motivation for the law. We know that even if if there was voter fraud, we knew it wouldn't fix it. But the people think it's a problem. And because they think it's a problem, that's enough of a reason to pass this law to give them confidence that the system doesn't have fraud. Think about that. Why do people believe that we have a voter fraud problem? Because they've been told. They've been told incorrectly over and over and over. All the court needed to do is say, if I go back to the coded language I had a few minutes ago about fundamental rights, you can't have an abstract statement that undercuts a fundamental right. You got to have facts, got to have evidence. If you're going to overturn a fundamental right, you better show that there is a, if not a compelling need, a significant need to overturn this right or to restrict this right. And it does not exist. And this is a standard that under the circumstances, there is, at least I will say, no justification. Okay, a couple of other points. I will give the court its due in one component of this case. The people who brought the claim could not show any examples where any of them were denied the right to vote. They could show that it was harder. They could not show that they were denied the right to vote. On the other hand, the state couldn't show any evidence to justify the policy. So, the court engaged in a little bit of this obscure esoteric debate about the record versus outside evidence, but there wasn't anything in the record to support either side's position in terms of restricting the right to vote. Why? In terms of the impotence placed on the right to vote, that was a problem. Okay, so why is Crawford so awful? I mean, I've painted this picture of a pretty terrible case, right? A couple of reasons. It downgraded the constitutional status of voting rights right at the point where the court could have said, voting rights matter. And they basically said, nah, they don't really matter that much. That's the first point. Second, they shifted the evidentiary burden, that point I just made, from the states to show there is a reason to restrict these rights to the voters who have their rights infringed upon. Because the state just has to show, well, we have some beliefs of people that there might be a problem with voter fraud. There isn't, but people believe it, so we're going to restrict your rights, and you have to prove that your rights are being curtailed. And again, they're not being blocked, they're just being made a little bit more difficult. Okay, so that's the second point. Third point that makes this a terrible decision. The justifications for the law were nonetheless sanctioned. The justifications have very little grounding in constitutional analysis. It's just the reality. Okay, fourth point. Well, I'll just build on this one a little bit more. They admitted again, as we said, that the law would not fix the problem, and the court ignored the actual fraud. By the way, I should have pointed that out. There was a little bit of evidence of absentee ballot fraud in Indiana. They didn't address it. They addressed the in-person voter fraud. Why? Because the data that they gathered to decide how to draft the law at the time showed that most of the absentee allegations were Republican voters. So we don't need to look at that because the other ones, these are the people we want to make harder to vote, right? And then this claim of public confidence, it is not an irrelevant concern. But when you weigh that against voting being a fundamental right, you just can't restrict a fundamental right based on speculation. That's not how voting is supposed to be protected. You put all of that together and you have a decision that is problematic, and we can show exactly how problematic it is by looking at the results. So what happened after Crawford was decided? I'm gonna do the speed version here as well. 2009, the case was decided in 2008. Over the next couple of years, almost half the states enacted similar laws. All of them except one was passed by Republican legislators, and that's photo ID requirements, just like the Crawford case. Okay, that's the first one. We go out a couple more years, and we have the Republicans winning a huge victory in the midterms in 2010, and then we have the Shelby County versus Holder case, which I'll say something very briefly about in a moment. That's the one that struck down the part of the Voting Rights Act that let laws like this be blocked initially by the Justice Department or by a federal court, pending an investigation that they were non-discriminatory. Okay, after that was lifted, every law passed by a Republican legislature, a lot more of these passed, and they expanded from photo IDs also to reduced early voting, making it harder for ex-felons to get their voting rights back, purging voter lists, letter perfect standards. For example, if there's a comma out of place in your street address, you can't vote. It's the difference between your voter registration and your ID that you show. Comma's out of place, can't vote. Social Security card for a woman, you're married, inconsistent name, can't vote. 400,000 women in Texas were denied the ability to vote with one of their laws when this happened. Okay, so anyway, pretty significant. And then one more. Over the decade after Crawford, we get a full picture. Every law again, except for New Hampshire from 2010 to 2020, was done by a Republican legislature. Whole bunch of these laws passed. 2/3 of the states have some form of restrictions on voting that were not there before before Crawford was decided. Okay, now better let me go back to where I'm supposed to. Okay, here we go. Yeah. Okay. And what about harm? I said the effect was immediate, sustained, and harmful. We cannot document easily which states flip or how many states actually voter fraud restrictions or voter suppression laws change the outcome. It is terribly difficult, but we do know that the more restrictions, the fewer people vote. And that's fairly well documented. This is just one illustration of it. Okay, so two more things I want to point out, and then I'll go to questions. First of all, I mentioned Shelby County. I don't want to make this discussion about Shelby County, but this case, the Supreme Court said that the Voting Rights Act was outdated, and the standard that was used to decide which states or jurisdictions in states had to comply with that pre-clearance requirement. You had a legacy or a history in your state of discriminatory voting laws, you had to get any voting law changes cleared by the Justice Department or a federal court, or they couldn't go into effect. And the standard for having that pre-clearance was different than the standard if you just sue after the fact. Okay, so what happened when the Supreme Court struck that down? Well, I already hinted at it with the graphics a few minutes ago, but just to clarify, within a year, every state that was subject to that provision had changed its voter eligibility laws. Every one of them. Justice Roberts, who wrote the opinion in that case, Chief Justice, said, we don't have this problem anymore. States wouldn't do this anymore. How long did it take them? To be fair, it wasn't just those states. Some of these provisions, Wisconsin put in new photo ID requirements. And after the obvious, driver's license, they looked at, okay, well, driver's license, some people don't have it. So what other options can you use? And they looked at, for example, disabled veteran ID was not allowed to be used. Why? Because they looked at the numbers, and most of the disabled veterans with the IDs in the state of Wisconsin were African American. But a concealed carry license could be used. That's Wisconsin. North Dakota is the worst of all of them. Ohio reduced early voting, but North Dakota, the state looked at a Senate race where overwhelmingly Native Americans voted for one candidate. So North Dakota passed a law that said, well, on the reservations where most of the, not most, but a lot of Native Americans live, you don't need a street address anymore. You just need a PO box. And then they waited another couple of years and they passed a law saying you can't vote unless you have a street address. And almost 2/3 of the Native Americans who lived on reservations couldn't vote in the next election. And we saw a reversal of the outcome of the Senate race. This is what gets done without the pre-clearance, without the safeguard on rights, on voting rights being fundamental. This happens again and again and again. Okay, so after Shelby, we saw that massive change, that massive acceleration of what was happening after Crawford. Okay, so what does that leave us with? First of all, Crawford opened the floodgates. The Supreme Court had one job to do in Crawford. This restriction, this line of restrictions on voting rights do not protect voting rights. We have constitutional language, we have statutes, we have constitutional amendments. We have to protect voting rights. The court chose not to. The vast majority of people today believe the voting rights myth, that there is voter fraud, and that is a justification for restricting voting rights. We've seen an acceleration of the voter restrictions again and again and again. I'd be remiss if I didn't mention the 2020 elections. President Trump, before the 2020 election even occurred, after 2018, initiated an election integrity commission. And he brought in some of the same people that had been pushing for and developing some of the laws that we saw in 2010, and 2012, and 2014. And they investigated, looked for voter fraud, didn't find any. And yet, in the 2020 election, I couldn't have lost unless there was fraud. We had an attempted overturning of the election by force. That doesn't happen unless people believe that there's something untoward, voter fraud is happening. And again, had the court shut that down when it had the chance, we wouldn't be in this place. Now that's a little bit simplistic, I realize, but when the Supreme Court is so open and so willing to just give carte blanche to these kinds of laws, we see that acceleration, and we have seen it for 13 years since the Crawford decision. And again, what's happened since 2020? 17 more states have passed voter restrictions after the 2020 election, responding to those allegations of fraud. Most of those this time have to do with not just building on the other laws that we've already seen, but restrictions on voting by mail, restrictions on early voting, restrictions on helping people vote. Right, the cases dealing with, and again, there are always exaggerations, but the restrictions on people giving water to voters, there's a logical explanation for that, but look at the optics. There are plenty of examples of restrictions that didn't need to be there, but were put on and put in place because it would make it harder for people to vote. It would make it harder for people to assist people to vote. People can go to jail for helping register voters these days. This is beyond the pale, and it is largely because of Crawford. So what we're left with is, and I thought I had my last quote there, so I will just go ahead and mention this here. The Supreme Court allowed this, and the Supreme Court has to fix it. Voting is a fundamental right, and the only way we get it treated as a fundamental right is to go back, revisit the Crawford decision, and get it right. Okay, I'll take any questions people have.
With the current makeup that we're stuck with of the Supreme Court, and we personally may or may not agree with this justice, that justice, so on and so forth. They probably are learned people. What is it holding them back that they cannot see that democracy is imperiled?
You know, I wish there was a good answer to that. There are examples, and I don't want to single out any particular justices. I mean, I I saw that decision when Crawford came out. The fact that Justice Stevens wrote it was shocking because that was not a consistent pattern with him. Chief Justice Roberts has a blind spot for contemporary and some history and contemporary events. Chief Justice Roberts makes comments from the bench in some of the cases. Well, you can't be telling me, counsel, that southern states are more discriminatory than northern states. Are you really suggesting that? His comment in the Shelby case that we don't need these laws anymore because we've seen a downturn in these discriminatory laws. Justice Ginsburg's response to that was that's equivalent to saying, well, I'm not getting wet standing in a rainstorm with an umbrella. You don't need an umbrella anymore because, so there's a blind spot there. There's also a belief with voting rights, and I think this is probably more of it. One, that there is a sense in which, even though it may be a right that ought to be protected more, the Supreme Court's majority is really hesitant to interfere with the states running their elections and the states managing their elections. That's not a good reason if you're looking at the treatment of fundamental rights by the states, and most of these laws, not all, Shelby isn't, but by the states passing these restrictions, the states get to control their elections unless they're violating some of these provisions. And the majority on the court has made a conscious effort to defer to states. That doesn't get changed with this current majority on the court. I don't see how it does. Unless they haven't upheld every law. I will give them that. They haven't upheld every single law that's been passed. There have been a few that were too egregious, and some of the circuit courts have struck down a few. There was one in North Carolina that was passed, and I'm going to get the year wrong. It's 2014. And yeah, it's right after Shelby. And North Carolina, the day after the Shelby County decision was handed down, the legislature asked for the Secretary of State of North Carolina to give them all the racial data on voting. And they collected it and they worked through and decided which IDs they're going to use and which early voting they're going to roll back. And the Court of Appeals said they targeted African Americans with surgical precision. And the court threw that one. So the worst of the worst gets struck down. But what about what they did in North Dakota? There is no explanation for that being upheld other than the court had better things to do than worry about it. It's depressing. And I don't like the fact that I stopped researching the project. I had a book proposal and I couldn't do it. I couldn't do it anymore. I couldn't study the topic anymore. And that sounds really bizarre, but I'm not kidding. If it wasn't, I'd love it if it wasn't partisan. I'd love it if it was everybody does it, because then you can bring people together and discuss it. But this isn't. This is a partisan effort to restrict voting for partisan gain. And the court has no problem. We all happy now?
Well, I have one more. It's a current, I think it's Wisconsin, where there's a proposal to collect like 10 pieces of information from all the voters, including the last, maybe it's Michigan, maybe it's Pennsylvania. It's one of those, including the last 4 digits of your social security. You know what I'm
I'm familiar with some of those proposals.
Do you think that's going to stand? I mean, that's a lot of information about everybody in this room if we were there, no matter who you vote for.
A lot of it depends on how it's used. I mean, if you gather this information and you use it in a way, you can use that information in a way that is non-discriminatory. Again, I focus this presentation on the abuses. About half the states, well, more than half the states have imposed these types of restrictions. There are several states that have gone the other way. Now, the majorities are different in the states, but what most of those states have moved towards is universal registration. Universal registration would solve the speculative voter fraud problems. If you're concerned about people voting illegally, you standardize the system and you have everybody registered by the state with this uniform policy. But of course, that's not wanted because that also, while it also it addresses the fraud, it also increases likelihood of people being registered. Well, it increases likelihood of people being registered, and that's not what they want. So there is a way to do this. There is a way to address the concerns about speculative voter fraud, but it wouldn't restrict people's rights to vote, and that's the goal. If you're that, I mean, I hate to say I'm that cynical, but that's the goal of these laws. And every now and then, people slip up and make it clear what they're trying to do. You know, voting ought to be, you know, I want people to have to walk 10 miles through the desert or 100 miles through the desert like the person in Africa. That was a guy in Florida talking about getting voting rights back. You know, I want it to be really hard. I want people to really value that right to vote. It's a nice sentiment, but we're not supposed to make it harder. We're supposed to make it easy to vote as long as we can verify. And again, verifying that people are allowed and properly registered to vote is not that difficult. But it's not getting done. It's getting done in a way that's designed to restrict the most vulnerable voters, make it harder for them to vote because we know who they vote for. And that's about as cynical as I hate standing up here and saying that. But that's where the evidence took me. Yeah.
You mentioned like laws or efforts being passed to limit those who are trying to like, help register people to vote or like increase more ID registration. I was not familiar with those laws.
The laws to make that harder?
Yeah.
I mean, it varies. Florida passed a number of laws, at least two that I can think of. The League of Women Voters pulled out Florida. All of their efforts for years and years to register voters. The restrictions that were imposed, if you make X number of mistakes, you follow, you know, they established a series of rules that were incredibly harsh. And then they had standards for if you register someone and it turns out there was a mistake or something improper, then you can lose your access and you're not allowed to register voters. Similar things were done in Ohio and in Texas. Texas's brand new law has some of that. And again, if you have a majority, you can do it. The restriction on giving people water while they're waiting in line, there's a plausible explanation for that. Okay, the plausible explanation is, you know, you could have people standing in line and someone comes up to them, hey, would you like some water? And, you know, the bottle has, or they're wearing tags with, you know, a particular party. And it's pretty obvious they're trying to, you know, we're the ones giving you water. And that they can pose restrictions. They can impose safeguards on that. But when the approach to the policy is you can't do that because that's the easiest way to do it, that violates the standard. Okay, the standard of strict scrutiny or the standard of intermediate scrutiny, you don't restrict the right more than necessary. And these examples are pretty clearly more than necessary. Let's just shut it down. Let's make it harder. You can't register people, or it's very hard to register people. Letter perfect standards are some of the most obscene things that have been done. Texas, North Carolina, Ohio, Wisconsin, Pennsylvania, all passed some form of letter perfect standards after Crawford. And I mean, I tabulated charts of all the different laws that the states passed, and it was just bizarre, just how far some of these states were willing to go to make it harder for their political opposition to vote. You can go after the voters, you can go after the people registering them, but just make it a little bit harder. And again, if you don't ban them from voting, it's almost impossible to document because the standard, you know, the standard under the Voting Rights Act to show that there is a violation under Section 2. And Section 2 is the one that you have to use for restriction of your voting rights after the fact. You have to show both that there was intent to restrict your voting rights and there were actually restrictions on your voting rights. And again, making it a little harder doesn't always meet that standard. So it's, I mean, I ultimately think it has to be reversing that decision. I don't see another way to do it. Could Congress reverse Crawford? Really hard to say because these are mostly state laws. And I don't know that Congress can reverse all of those state laws when the Supreme Court has interpreted the Constitution the way it is. Anything else? Yeah,
I have a question. Last semester we gave a talk about Brown versus Board of Education and its impact. My question is with Crawford v. Marion, is there any connections that trace back to Brown versus Board of Education?
it would be a really convoluted connection. I think where I actually see a connection is the color blindness of some of the justices. The same way that they looked at Brown versus Board. I mean, my premise for those of you who weren't at that one, and there were 10 people at that one. The premise there is that was a little more harsh, I guess. But I looked at the way Chief Justice Roberts has been interpreting Brown versus Board, and I see him thinking it's Plessy versus Ferguson. When he describes what Brown is about, he keeps discussing everything about Plessy except separate but equal. All of the standards that he says he attributes to Brown are actually attributable to Plessy versus Ferguson. And some of that's driven by the fact that he believes that the Constitution ought to be colorblind, that the job of the courts is to ignore race, do nothing about race. And if the court considers race, then the court is violating equal protection laws. The problem is that if the state laws are discriminating based on race and the court can't step in, the court's being colorblind, but it's perpetuating racial discrimination. And I think that's the only place I would see that kind of connection. I think there is some kind of the approach being used by some of the justices tracks there. But and as far as it being, this is a different set of doctrine. Voting rights being a fundamental right is the issue here. Ultimately, the issue here as opposed to the equal protection standards. Really good question. It is warm in here. I was, rushing over here. I backed into a tree on the way here. And shouldn't have shared that. The topic frustrates me. Anyway, again, thanks everyone for coming. Come to the next couple. There are some really cool topics coming up. I had a really cool title, but some of these upcoming topics are going to be really interesting topics.